Is very different than me. Her story is different than me. Yet at the same time, I brought more of myself to this movie than I ever have before. And I think that more than any movie I've ever done, like, Lily is such a ball buster. I am rotten to the core when it comes to that. I am very, like, if I'm not busting your balls, then you should be worried. Then I'm mad at you. Then I don't love you. You know, and just the way that I sort of use humor and levity in moments of sadness or pain, because that's the prism through which I can cope and deflect, and I smile in sad moments because it's just how I process things.
Welcome back to my channel. It's another day. It's another Blake Lively PR stunt today. It is an amicus brief that was filed in court by 3 nonprofit organizations that assisted in drafting the law, AB 933, which is the law that Blake Lively is attempting to hide behind in order to say whatever she wants about Justin Baldoni, outside of evidence, outside of facts, and beyond the fact that she's the one who did the harm in this instance, beyond the fact that her own firm once was literally charged with SH and she squashed those allegations. And beyond all of that, an amicus brief, which is typically not included in a motion to dismiss amicus briefs, are typically filed in the appellate court, and in this instance, the brief is being utilized to attempt to sway the judge to dismiss a case and accepting claims as fact that have not been established as fact in the court. So today was one of those days, and there was another one too, a filing by Jen Ale against Stephanie Jones that will be overpowered by this amicus brief that is all but an PR stunt, because this amicus brief is months behind and irrelevant to the motion to dismiss. It's a band of legislators that assisted in making a law that want to inform a judge that if you decide incorrectly on this, you will damage everyone while they profess to be supporting Lively. They do not understand that Lively's assertions cannot be relied upon, and that's my view. But Jen Ale is taking a stand against Stephanie Jones' Abel, whose phone was hacked and utilized as splicing and dicing to produce the idea of a claimed smear campaign by Stephanie Jones, who then gave over the contents thereof to Blake Lively by way of fictional subpoena and lawsuit within the state of New York. Disregard that laws were broken by Lively. Disregard that there's hacking claims here. Disregard that there's wiretapping charges in these lawsuits. Disregard that there's extortion. We're supposed to also disregard all of the evidence, the long history of Blake Lively's lies and deceit, and her husband's lies and deceit, and their threats towards people, and their intimidation and their bullying. Discount all of that. We are to just take as true that Blake Lively reported it happened to her, despite the fact that there's no proof, and because she does not possess so much as a single witness who can come forward in her defense, because nobody witnessed it, and nobody will confirm it. And all of her evidence has literally been torn down and ripped apart by actual evidence. Now she's relying on advocacy organizations who assist in drafting legislation to inform a judge. You have to dismiss this case that Justin has brought because, we said it, their use of filings for PR knows no limit. But before we get into that, I'd just like to bring something up, because there are women who have been victimized in this particular case. There's one woman who comes to mind. Her name is Jennifer Ale. She's a PR publicist who works in the state of California. I don't know if you know who she is, and there's another woman named Melissa Nathan. Both of these women have been maligned in the public and referred to as haters and abaters of sexual harassment that led smear campaigns despite the fact that they had nothing to do with that. Despite the fact that there was no smear campaign, there are real victims here that are women. Jennifer Ale and Miss Melissa Nathan, who are being injured in this lawsuit through false allegations. And as you are aware, Jennifer Ale has some actions that she has instituted against Stephanie Jones, and it is actually Stephanie Jones who initiated entire smear campaign against Blake Lively. It was done by Stephanie Jones, and Stephanie Jones, her former employee, Jennifer Ale, is being sued by Blake Lively, although the time period for which Blake Lively is suing Jennifer Abel, because she was working for Stephanie Jones as an employee of Stephanie Jones and being a public relations specialist under Jones Works. For some reason why Blake Lively isn't suing Jones Works, despite it being Jones Works and their workers who quote-unquote smeared her, I just want to show you how they responded to Stephanie's motion to dismiss. Because it's a thing of beauty. Do you recall when I said that Stephanie was adding screenshots and referring to complaints and answers that are beyond the complaint, the third-party complaint, and outside of the complaint in general, and that Stephanie was adding extraneous information as factual allegations that had nothing to do with the third-party complaint? Well, they noticed that, and they asked the court to ignore their improper factual allegations. They said, when deciding on a rule, 12b6 courts may review only a narrow universe of materials which includes facts stated on the face of the complaint, documents appended to the complaint, or incorporated in the complaint by reference, matters of which judicial notice may be taken, as well as documents not expressly incorporated by reference in the complaint, nevertheless integral to the complaint. So saying you need to remain with inside of the complaint, here's what they said Jones Works did. Jones Works improperly cites Lively's amended complaint to introduce alleged facts in support of the motion. However, when determining whether allegations in a third-party complaint can withstand a motion to dismiss the defendant, third-party plaintiff is not considered to have admitted the allegations in the main actions complaint. To the contrary, that allegations of the initial underlying pleading are irrelevant. Nonetheless, the motion improperly cites her amended complaint 14 times. None of them can be considered on this motion. Also contend that Jones Works routinely cites Abel's amended answer to Lively's amended complaint, and to Abel's amended answer to Jones Works complaints, even assuming the court takes judicial notice of Abel's other pleadings. The court should not consider the spliced and/or cherry-picked communications that Jones Works tries to spin into factual allegations, for example citing paragraph 76 through 86 of Abel's amended answer and pasting bits of what are alleged to be text message into the motion. Jones Works misrepresents to the court that Abel admits she actively worked to discredit Jones Works' reputation. A simple review of Abel's amended answer discloses that in response she either denied the allegations or admitted to sending the referenced communication, and denied that Jones Works' pleading had correctly characterized the communication as another example of her deceptive conduct, citing a paragraph 33 of her amended answer to Lively's amended complaint. Jones Works alleges that Abel developed and implemented a smear campaign to bury and destroy Lively. In fact, paragraph 33 admits that Abel sent a communication, specifically denies the communications and their context are described accurately in the complaint. The court should reject all of her attempt to mischaracterize Abel's factual allegations. If you have to splice and dice your content and splice and dice your response and lie and try to mislead, a judge isn't stupid. The judge can read what you are saying and see that you're not representing this as fact. It's amazing how these PR people can spin these documents, and they think that they're doing PR, and they forget that they're in court. What really irks me about the level of power and influence that Blake Lively has is that she's able to get advocacy groups to take her at face value due to her name and due to her husband's name, and because these big corporations make movies for them, and yet these people, these advocacy groups, these supporters of hers, they all state that Blake speaks for all women. And I think, I don't know, I've made accusations of SH and SA. I actually went to the police and wasn't believed, and you know what? When I was going through my process, not once did any advocacy group step in and put themselves into my case and say that if the police didn't charge this guy, then somehow it would be injustice to all victims. I really hate when absolutes are made. When you say if you do something, then everything else will be X. Like it puts into your mind doom or gloom. If you don't do something, it's catastrophe, and the world is going to end. It's a fear tactic, and it's veiled under this principle of advocacy, a single ruling in court on a tainted case on a lying plaintiff making false claims. And if a judge rules and does not grant the motion to dismiss, that does not mean that it is a blatant disregard of other victims. It means that this victim isn't believed, and in this instance with Jen Ale, her perpetrator is her ex-boss Stephanie Jones, and you'll never make me think otherwise. Stephanie Jones is the one who went to the Daily Mail and initiated this whole press campaign against Blake, but Stephanie was the one that said that went to the Daily Mail. Stephanie's the one that called it a nothing burger. Stephanie's the one that went out to defend Justin when Justin and Jamie at Wayfarer said, "Do not talk to the press, we are not speaking to the press." Nobody was talking to the press. They can't cite one time that Jen Ale is on record with anybody. They can't cite a single person or a single story that Jen Ale released into the public that was in response to whatever allegations that Blake Lively made. Blake Lively is using sexual harassment as a weapon, and she knows how to use loopholes and laws to her advantage. And it sucks to be on the receiving end of this type of litigation for Jen Ale. Because how do you prove a negative? You can't. She has all kinds of evidence that's documented that shows what she did and didn't do. She's given most of this to the court either in text messages with Justin where Justin gives his side because she can't give her side because Stephanie stole it from her, or Melissa Nathan shows her side and they can see the whole context between Jen and Melissa. And all the while Stephanie Jones was a part of all of this. And let's not be disillusioned here. Do you know who's actually being retaliated against Jen Ale? Because in her lawsuit for the amended complaint for the third party complaints, she is being sued because of losses she sustained in the discharge of her duties of employment. That's retaliation. She's being sued because of things that occurred when she left her job. Accusations were made against her by her former boss, because her former boss is the one that did it and is setting up Jen Abel, and it's her former boss that hacked into the phone and gave Blake whatever Blake wanted to show Prover. And the fact that in Blake's complaint she can literally say that Jen Ale was working for JonesWorks and was an employee of JonesWorks, and not include JonesWorks in the lawsuit is insane, because you know who else was a part of this. There were other people in at JonesWorks that were a part of Justin's file that were handling his PR. There was a guy that was a part of this. Why isn't Blake suing the guy? He was as much a part of it. He was the one talking to them. He was the one that was adding her to text threads, and they had meetings about everything and how they were going to coordinate the PR. Jen wasn't the only point person. She was like a team of people. Why isn't Blake suing the whole team? Why isn't Blake suing? And something that's being lost, I think lost on a lot of people, is that Wayfarer talked about hiring an attorney in August, early August, before this quote-unquote smear campaign began. And Brian Friedman was contacted by Melissa Nathan on August 12th. August 12th, Jed was hired, I think August 8th. The movie opened August 7th. So Blake is going to say a retaliation campaign occurred in 4 days. 4 days. They were talking about hiring a lawyer all the way back in May. Do you really think this team was going to initiate a retaliation campaign against a woman that had been threatening to sue them for months? And then do you really think that Brian Friedman would have come in and unethically assisted and abetted a smear campaign against Blake Lively? And how does anything even compare to all of the things that Blake and Ryan released about Justin Baldoni to the press? All of the articles to the Daily Mail and to Page 6 about Justin the unwanted kissing, the lingering kiss, the fat shaming that we've all seen, didn't occur. Blake Lively's lies over lies over lies, and Jen Ale literally discussing with Melissa Nathan, discussing with Brian Friedman on August 12th. August 13th, more discussion about Brian Friedman. Brian Friedman entered into this case in August. Wayfarer was considering a lawsuit against Blake, because on August 12th, Blake stated, "If you don't put this out about me and apologize for this production, the gloves will come off." And when the gloves came off, they hired Brian Friedman. Why, what does it benefit him to smear his own movie? And the leading actress in his movie, there's no benefit, it hurts his movie. And who's the one that actually smeared? Who's the one that was constantly running to the press? It was Stephanie. And who is the one that botched up the PR strategy that they had established of not responding to the press? Who was the one that ran to the press? Stephanie Jones. And in their response to her motion to dismiss, they state the third-party complaint also alleges that Lively's claims against Abel are grounded upon acts that Abel performed in furtherance of JonesWorks' business, and that Abel was employed and directed by JonesWorks and Stephanie Jones to do. Specifically, Abel's pleading alleges that the conduct alleged by Lively to have been committed by Abel and to have been caused harm to Lively consists of public relations activities on behalf of Wayfarer and Baldoni during the time period when they were clients of JonesWorks, to the extent any of such conduct by Abel was undertaken as alleged, which Abel disputes. It was undertaken in obedience to JonesWorks' directions. And indeed, the third-party complaint alleges that according to Lively's own pleadings, Abel's position as an employee of Jones Works directly gave rise to the so-called retaliatory campaign of public relations activities against Lively, which Abel disputes. The third-party complaint alleges that Lively's allegations against Abel, the veracity of which AEL disputes, are of conduct and communications directed at the press and the public to garner good publicity and to eliminate or minimize bad publicity for their clients, Wayfarer and Baldoni activities, which are the very essence of the public relations profession. Notably, not only does the third-party complaint allege that Stephanie Jones directed Abel to perform any purported public relations activities that are the subject of Lively's claims, but the third-party complaint also alleges that Jones Works owner Stephanie Jones participated in any such activities. Specifically, the third-party complaint alleges that Stephanie Jones' public relations blunders and incompetent handling of communications with the press only caused negative stories concerning Lively to circulate further and attract greater attention. Hence, the court should not give weight to Jones Works' improper factual allegations that Abel went rogue. The third-party complaint alleges that Abel was named as a defendant by Lively only because of and in direct conscience of Abel's discharge of her duties as a competent public relations professional employed by Jones Works, and that Abel acted within the scope of her authority, and that Jones Works profited and was enriched by the fees paid by Wayfarer and Belden for public relations services that Jones Works directed Abel to carry out the alleged public relations activities that are the basis for Lively's claims, and that Abel was not at fault and bore no responsibility for Lively's claims. And then it goes on to say, to distract the court from Abel's well-pleaded allegations in the third-party complaint, they cites Abel's pleadings in the related case of Jones versus Abel, and then mischaracterized the nature of the allegations therein, citing to paragraphs 4075 to 82, and of Abel's amended counterclaims in the Jones case. Jones Works incorrectly contends that Abel coordinated an unsanctioned smear campaign for Wayfarer and Baldoni against Lively in purport defiance of Stephanie Jones's instructions. In truth, Abel alleges in the Jones case that Stephanie Jones participated in meetings, calls, and written correspondence related to public relations crisis involving Belon, and Lively. Jones was copied on virtually all communications during this period and was privy to Wayfarer's predicament and its chosen strategy of non-confrontation. Jones admitted that she was deeply involved in strategy planning and account management and high-level PR and media communication in August 2024, and Jones would have been contemporaneously aware of any smear campaign against Lively if it existed, and in contravention of Wayfarer's instructions to not speak with the press about Lively, Jones spoke with the Daily Mail and sparked a chain of unfortunate developments from a public relations perspective and concerning Lively. Hence, the amended counterclaims in the Jones case alleged that Jones sanctioned and participated in any public relations campaign at issue in Lively's pleadings, and did not reject it as Jones Works now contends. Jones Works' contention that the alleged public relations campaign at issue in Lively's claims represents a significant departure from Abel's normal duties and were beyond the scope of her employment is refuted by the third-party allegations, which the court must assume are true, as detailed above. The pleading alleges that Jones Works is a public relations firm, Wayfarer, and Baldoni were their clients. Abel was employed by Jones Works to provide PR services. Any public relations services provided by Abel to Wayfarer and Baldoni that are in the subject of Lively's claims were performed to garner good publicity and to eliminate or minimize bad publicity for their clients' activities, which are the very essence of PR professionals. Jones Works and Jones directed the public relation activities at issue. Stated differently, the per third-party complaint sufficiently alleges that the conduct in which Abel alleged engaged were her normal duties and within the scope of her employment. Basically, the nutshell is that they hired Melissa Nathan, and Nathan didn't need to do much, and all Abel did was her normal job. And as for Jones Works' contention that Abel cannot plead innocence or mistake, that is a red herring. Abel does not allege that she made an error or in judgment or mistake, but rather that she carried out her public relations duties as she was employed and directed to. By Jones Works, Jen Abel has a right to defend herself against claims that are being made against her, as does Justin Baldoni, And under the Sixth Amendment in the United States, we all have a right to defend ourselves against claims. And we have a right to due process. And due process also isn't just about criminal court, it's about civil court. And a part of due process in the United States federal court is that someone gets to defend themselves against claims of sexual harassment or sexual assault or whatever the claim is. And another aspect of due process under the U.S. Constitution is that you are able to file counterclaims against the person that's bringing claims against you. It's a fundamental right for every United States citizen. It doesn't matter if you're a man or a woman, it's a right to all people. And what this California law is trying to state is that if you bring a claim of sexual harassment or sexual assault, and you make it publicly known, and you don't file something in court that you can't be sued and that no one has a right to sue you, and that if they do, it's retaliation. And that's not what the Constitution says. What this law is doing is it's being the judge, the jury, and the executioner, and it's actually the opposite of due process. And it's the opposite that we are instructed as United States citizens that someone is innocent until proven guilty. And just because someone brings a claim doesn't mean they're guilty, and that in the state of New York, you can bring just about any claims. And it's barred from defamation. And so as Judge Lehman has stated, not all court filings in New York should be taken as fact and should be actually read with a grain of salt. So then to go to a court after which the statement was made, Blake Lively has brought in the big guns and brought in organizations who helped draft this law in the state of California, which I believe is unconstitutional, and I'm a victim of SA and SH. I hate that this is happening. But you have to respect the Constitution. You can't deny someone the right to defend themselves. And you can't allow someone carte blanche to just make up whatever they want, because there's always going to be bad actors. And there are up to 10% of claims of SA and SH that are false. So that means there are going to automatically be people that abuse the law and weaponize this law to say whatever they want about people. And so 3 separate companies, the ERA, the California Employment Lawyers Association, it's an organization of 1,300 California attorneys who primarily represent employees in a wide range of employment cases, and the California Women's Law Center are going to address the court about issues in the motion to dismiss. It's another way for Blake to get someone else to argue to her, the court, that they need to throw out her case. And immediately after this was filed, the LA Times had a statement released by these organizations. So it's a press release, that's all this is. It says, The proposed brief would help this court by explaining the purpose and legislation history of California Assembly, Bill 933 at issue in the case, and they enacted not AB 933, now codified at California Civil Code 47.1, to combat the onslaught of retaliatory defamation suits filed against victims of sexual assault and harassment who speak out about their abuse, and specifically to shield them from a discovery process that has become one of the prime weapons in such suits. The irony here is that Blake already has her own discovery, and she's actually abusing Justin and wants information on the rights of the movie. But whatever California people that want attention in the media the prop, the proposed brief begins by situating AB 933. In a broader context in recent years, retaliatory defamation suits have become a core part of abusers' playbook to deny abuse, attack victims' credibility, and cast themselves as the real victims, with devastating consequences for survivors. And the public at large, someone with the resources of Miss Lively is an aberration. Most survivors are low or middle-income advocates, including Massey, have seen survivors buried under legal defense costs they cannot afford, while others struggle to obtain legal counsel. None of this has to do with Blake Lively next. The brief traces the specific legislative history of AB 933, highlighting its twin purpose to shield victims from discovery processes by allowing them to prevail at motion to dismiss stage in most circumstances, and to remedy the financial and physiological costs of retaliatory defamation litigation, and deter abusers from pursuing such litigation in the first place. They're saying that this is to champion the rights of workers and victims of SH and SA, and to share a special interest in ensuring the courts apply the intended legal approach to this new statute to to ensure that all Californians, particularly low and middle-income individuals who cannot afford legal defense for speaking out about harassment, and abuse, enjoy the full and robust protection that state lawmakers intended. You know, it's an odd choice for them to intervene, but they got a headline out of it, right? Victims advocates stand with Blake Lively, and in their brief they tell the judge that, everything that Blake has said is true. And they blame Justin Baldoni of employing Darvo tactic, who's the one that's always darrowing her victims. Blake Lively in the several amicus briefs, which I'm not going to read because they haven't been approved by the judge, hasn't approved them. They attempt to lay the blame at Baldoni's feet for destroying Blake and Taylor's relationship, despite the fact that it was Blake who introduced Taylor to the scene, and Blake and Taylor doesn't defend Blake. So why is it Baldoni's fault that Blake threatened Taylor Swift? It isn't. So why are these out of place and irrelevant under the federal rules of procedure to be received into the court? An amicus brief must be filed 7 days after the original brief was filed by the party, which they're supporting, and they're supporting Blake's motion to dismiss. Okay, Blake filed her motion to dismiss on March 20th. If they were serious about this brief, it would have been filed on March 27th to support Blake Lively. Instead, they've waited 2 months. Blake's brief wasn't fully briefed until mid-April. The judge has the time from the movement's completely briefed moment until 6 months to decide they are filling out of time, and it has absolutely nothing to do with this case, because Blake is the very first one to bring this into her court case, doesn't mean Judge Lyman will decide on it, and it only concerns defamation. Blake is being sued for so much more than defamation here. There has been so many various individuals that have emerged and so many individuals that are opportunistic in this, and I'm not ruling out the victims that this is purporting to assist, but if you're a mother of a son and I am laws which chill the speech and the defense of a man against a woman is creepy, because there's a lot of Blake Lively's out there. There's a lot of Amber Heards, and there's a lot of Robin Browns from the sister wives. There's women who lie. There are women who make up stories of sexual harassment. There were women that use whatever they need against them to have their way. There are women that break the law. There are women that kill, that commit fraud, that go to jail. Simply because you're a woman doesn't necessarily mean that you're a good person, only means you're a woman. And I do realize there is a culture of fear, and it's frightening. And many times as victims we aren't believed. But creating laws that then remove rights from other individuals doesn't benefit anyone. Laws must be examining the Constitution, and don't fault someone for continuing on. If it's constitutionally valid, blame the legislators for not anticipating this issue in advance. There are some other laws that have been nullified as unconstitutional that have been introduced and enacted into law in California. They actually had a law get overturned, where California had made it a requirement for every single corporation to have at least 3 women on the board of directors of any large of any publicly held company. So if you were a company in California, you automatically needed 3 women on the board, regardless of whether they were qualified or not. And the law was overturned due to the equal rights of everyone to apply for work. And if there's all equal candidates and they all belong to the same background, the companies can choose the right candidate, irrespective of gender. Being female is tough. Sometimes, we definitely get the bare end of the deal, but then again, we can't ask for special treatment. Being equal doesn't mean we receive something that's greater than someone else receives. Men aren't looking and demanding the courts not permit victims to have charges pressed against them. Imagine if that was a law. It's no different than a law that says you can't defend yourself. Imagine being accused of a crime you didn't commit. And then the judge says you don't get to defend yourself, you're going to jail, and it's just because someone said you did it. What kind of justice system is that? Blake is not the token sexual harassment victim, and the level of influence she has is seen by the fact that these huge organizations are stepping into her case and attempting to convince a judge to dismiss her case, and taking all of this as irrelevant, and that Justin has no grounds whatsoever for this. It's just a case of retaliation. Well, that's strange. Justin was thinking of filing a lawsuit against her in August before she even filed against him. So how is it retaliation? She filed first ahead of him, and now it looks like he's retaliating against her, and that, my friends, is Darville. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you are new, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.